according to a traditional view, international law is construed as a set of rules made through the lawmaking channels recognized by the doctrine of sources and interpreted through the doctrine of interpretation. This view, which is sometimes called mainstream, is the approach defended in the textbooks. It is also an approach that informs the judgments of international courts and their advisory opinions, as well as the reports or the guidelines and articles adopted by codifying bodies like the International Law Commission. This is the traditional view. I prefer to call this the orthodox view rather than the mainstream view. First, because I do think that the very idea of mainstream has turned very pejorative in recent discourses. Whereas I am of the opinion that one shouldn't look down at such orthodoxy. Even if I don't share it, I do think that it is one of the many approaches to international law that is possible. The second reason why I'm rather reserved as to the use of the term mainstream to describe this orthodox view pertains to the fact that nowadays there are very few colleagues and practitioners that fully endorse such an orthodox view. I do think it's one of the great legacies of critical thinking that international lawyers are more aware of the limits of the traditional models. I do think that critical legal studies, or what we call critical legal studies, has become a popular line of thinking, possibly turning itself into a sort of new mainstream. So approaching international law with a critical touch is nowadays rather common. Hence, I don't think that this orthodoxy, which I have described, deserves to be called the mainstream. Don't get me wrong, I am not saying that international lawyers have completely processed the lessons of critical thinking. I think they exaggerate the extent to which they have understood critical thinking. They think they have drawn the lessons from the very compelling works that have been produced in the last 20 years. Yet, I do think that critical thinking has left its mark, and we don't speak about international law nowadays like we used to do. This being said, the orthodox view, based on rules, sources, and interpretation, remains dominant, at least in the practice. If you want to articulate a legal claim before the International Court of Justice, these are the modes of legal reasoning which one should rely on with a view to producing an authoritative legal claim. And for that reason, that orthodox view remains important and must remain taught in universities, because that's how you speak the language of international law. There are many ways in which international law can be understood. Actually, international law is what you want it to be, and what you want international law to be depends on what you want to achieve with international law. The most dominant views about international law are the approach is based on rules. International law understood as a set of rules. International law as processes or set of processes leading to the generation of some authoritative decisions. These are views which I have been sympathetic to in the past. I must say that more recently, I came to understand international law primarily as an argumentative practice. By argumentative practice, I mean a discourse that is organized and highly structured around some key modes of legal reasoning. In that sense, international law is a discourse which is due to take place within the world of possibilities that are created by some key modes of legal reasoning. Modes of legal reasoning like sources, responsibility, statehood, interpretation create the world of the possible and the world of the impossible. International law is meant to be this type of discourse in the world of the possible, as defined by these key modes of legal reasoning. This discourse has a very specific goal. So international law as an argumentative practice, that is, as a discourse that takes place within the world of the possible, is meant to generate authoritative claims. So as an argumentative practice, international law boils down to claims for authority. The reason why actors resort to international law is to universalize their interests and possibly the interest of others with a claim for authority. Producing an authoritative legal claim is the very function of international law as an argumentative practice. Saying that international law is an argumentative practice also comes with a very specific understanding of the institutions that are involved in the business of international law. And here I want to speak of international courts. From the perspective of an argumentative practice, international courts can be understood as bureaucratic bodies that are resorted to produce authoritative decisions. In other words, courts are a service provider. The service is to generate a decision that is sufficiently authoritative. That's why actors resort to court. Courts will generate authority by resorting to the traditional and more orthodox view on international law, they will generate the image that their decision is inferred from some pre-existing standards and articulated around some modes of legal reasoning which are allegedly accepted by all the parties. This is how courts perform their function and generate authority. In that sense, understanding international law as an argumentative practice does not necessarily come with a repudiation of orthodox views. Because from the perspective of the argumentative practice that forms international law, the orthodox views is the very language which is used to produce authoritative legal arguments. And in that sense, even if we may not share the orthodox views on international law, and I certainly do not embrace that view, even if we don't share such an orthodoxy, I believe that we're bound to accept that all the various approaches to international law are bound to coexist and to reinforce one another.